Okay, I think we're going and we're live here. Alright, YouTube community, we're back, and I want to focus on argument and standing. This is where, and what I'm hoping to express to individuals that are trying to learn the law, understand the law, at least in our courts. They're fastest to law, but if you either go into law is how it services the people. Law is for the people and to protect the people. That is what law is for. So the person has to use either the law to protect themselves, and the government, of course, uses the law to govern others. So when we have a dispute, then we have a standoff of causality. Okay, so we have a case. We have a complaint. Complaint is brought to this person says this, this person says this. Who's right? Who's wrong? Where does blame lie? And what is the recourse, or what is the remedy? That's it in a nutshell. And so when we bring our point, our argument to the courts, it would sort of, especially for those that are representing yourself, and with respect to interpretation, again, here, and for example, just saying representing yourself, there, you have to understand there's a difference in terminology and the classification of words. Representing yourself, they call it pro se. Okay, you are not pro se if you are sovereign. Pro se means you have accepted their definition of one who stands alone versus the other. So you're standing alone, whether it's the court of the people or whoever's complaining, and then you stand alone or you stand with counsel. And so if you are your own counsel, which is sovereign, then you are not pro se. You are sui juris, suijuris. And so all these little things that are there, innuendos, we have to learn to stand our ground, our square, and assert our rights. The legal system as it is already designed to answer to the straw man, to the answer to the fiction, or the legal fiction, or the legal title, or whatever colloquialism you want to use. But that identity, which is a corporate identity of your name as your physical being, and they are two different things. You have to understand that's how the law is, and therein lies what they call that slippery slope, and why it exists in the first place is because, again, like I said, interpretation, the thing that I hate the most. I wouldn't say hate, but I hate that it's being used as a area to redefine law and thus undermine the principles. But with respect to interpretation, for example, a lot of people don't understand and don't know that you have the United States of America. Okay, capital U, lowercase, NITED, capital S, lowercase, TATES, capital A, America, okay. And then there's one that is the United States of America, that's all caps. Okay. To the naked eye, it seems like the United States of America. It is interpreted by law as what is on paper. And this name with different caps is different than this one. Therefore, it is different meaning, different understanding, separate position. And that's the problem. Our forefathers didn't know in the 1930s and the early 1900s, even before then, 1800s, the corporation, gosh, I want to say 1868, somewhere around there, corporations gaining power and how they used the law and lawyers and attorneys to redefine and reshape their agenda. So as a result of this, we have become a global, worldwide commerce planet. And that's cool. So with the commerce and with the trading of product and commerce comes regulations. And those regulations, the UCC, Uniform Commercial Codes, is supreme. So what we're getting at here is the use of our ground, our standing, which is a free man standing argument. And that argument can only be made in commercial courts using the UCC. Everything else will just be, and the judge, unfortunately, can stand behind what is known as plausible deniability. Because as he sits there, he's listening to your argument, partial terms, okay, and he's thinking Iraq, like we talked before, issue, rule, application of the rule, what am I going to do to conclude this matter? And if your argument isn't presented in a way that already pre-answers the questions of issue, rule, applicable laws, and the conclusion, then you've given the legal system a chance to say, well, one, you're incompetent to the law and thus do not make sense. And if your argument doesn't make sense, you have no valid argument. If you have no valid argument, then you have no valid case. And so a lot of them, you know, some minor technicality, and so it's like the legal system doesn't have time to teach you the difference in law and how it's interpreted. You have to do that on your own. That's why we're doing what we're doing, but it is necessary. That's why I'm doing what I'm doing. So as we learn the interpretations, the difference between United States of America with just the first letters capped and United States of America all capped, or your name first and your name all capped, and how this is viewed and what grounds or jurisdiction, that word again, stands. So when we come to court and we're arguing, you know, free and sovereign, if you do not spit out the applicable with your issue, driving, the rule that applies, the CCC codes, UCC codes that apply to traveling, or your rights as a traveler, or as a now how the judge applies that, how you've applied that to your argument. You've already knocked out steps 1, 2, and 3. The judge has no choice but to conclude in what is known as in harmony. This is an actual legal term. In harmony with common law. Because you have common law, of course, like I said, that existed before America was even a twinkling in Christopher Columbus's eye. And then you had common law, so now you have this commercial U.S. law, however they want to define it. but it still has to have a harmonious agreement within the color of law for all law that's binding all across the world. Okay? So when we stand in that knowledge, on that platform, thus we are able to present an argument correctly. And there are remedies. Presenting your argument with the remedy already ready, I mean, think about it. It's like you walk into the cell phone store and they see you, and you type in your information, and already they already have your phone ready for you from walk out in 30 seconds, activated. I mean, of course, that's an ideal, perfect world. Probably will never happen, and a horrible analogy maybe to what I'm trying to say, but it's the first thing that came to mind. In other words, it would just be speedy and easy, and it's not that way all the time. Back to this, we're on 11 minutes. So again, the argument that we're trying to present: why does this law have no jurisdiction over you? Well, that's the issue. The issue is you're sovereign, and the law, this part of the law does not govern. These are rights afforded you. Okay, and why are these rights afforded you? Because I'm sovereign. Because no, it's not because of that. It's because the law reserves, your rights are reserved, and the UCC code reserves rights. It's what it's very much about. And so stating that your rights are reserved is the first ground you want to stand on. Common law, jurisdiction, all rights reserved. You've given two buzzwords. The judge already knows where this is going. You follow this up with the applicable rule and how it applies. There's only one conclusion to draw: that this law, which is Uniform Commercial Codes, is a law that our law cannot ignore. It must be harmonious balance, and thus equal ground. When you're equal ground, then you're sovereign. Now you're equal with the other jurisdiction, and then there is a mutual, okay, you go your way, I go my way, and all ends in peace. And that's what it's essentially what it's about. So again, learning the definitions, get into the essence of law, read the codes. When you read anything in law, read it over and over and over again. Kind of like people say about the good book or the Bible or whatever. You read it and you get different meanings, and yeah, the law is the same. It's alive. It's constantly alive. People are alive, and it's changing. It's forever changing. So you have to keep up with it and so that's how it goes. But you have to also understand that it boils down to those principles that I spoke of earlier. Those three: interpretation, jurisdiction, and principles. Okay, so I'll leave you with that, and look forward to expressing more and answering more feedback, and enjoy the conversation. Keep it coming. Thank you. Have a good day.